I'm a partner and head of the health and social care team at RWK Goodman. If you don't know us, we're a top 100 firm and we're a recognised market leader in the social care sector. We work with adults and children's providers. Let me make sure my slides are working. There we go. These are some of the things we cover for adult social care providers. We are working with Devon Care Homes Collaborative as a partner. Any of our team are very happy if you would like to pick up the phone and just have a query. I'm probably your best starting point. Can you hear me? Oh, is that feedback? That's great. Can we all just go on mute? Is that okay? Thank you. Yeah, if anyone's got any legal queries, please don't hesitate to get in touch. We're very happy to try and answer things quickly if we can. So I am a specialist corporate commercial lawyer. I deal a lot with sales and acquisitions of care businesses, but as you'll find out today, I also deal with service user and commissioning contracts and a bit of non-contentious CQC stuff. So I'm quite I've got a wide skill set in the social care world. But today we're talking about admissions processes and residence contracts, and I'm going to cover the very dry law on this, so I will be brief on that front. A bit about the Competition and Markets Authority, which kind of sets the scene for where we are, key stages in your admissions processes, a bit about key risk areas in contracts, and I'll close with some very brief practical steps to help with sort of financial viability and debt issues, which are always a hot topic. So what is the law? This is good old contract law from law school stuff. There are three main bits of legislation. You've got the consumer protection from unfair trading regs. These basically are a prohibition from engaging in unfair commercial practice. And I should say, just to state the obvious, really, when you're dealing with residents and their families, they are consumers, which is why you're under the ambit of consumer law for them. And that consumer law will apply to residents, however they're funded, whether they're private or local authority funded. A commercial practice to where this applies is any practice directly connected with the promotion, sale or supply of your services. So will include your marketing, your admissions processes, your services, actually providing care, enforcement of contract terms and complaints handling. And basically you need to be truthful and accurate at all times when dealing with your service users, and that includes misleading omissions. So you need to give people throughout the process sufficient information so that they can make informed decisions about whether to come and live in your care homes. Your terms and conditions need to be fair, and that's something I'll talk about when we get onto contracts. And you must have a written complaints handling procedure which is fair and accessible. And that, is a given anyway, isn't it? Because CQC require that. So I don't suppose that's difficult to comply with. Then you've got the Consumer Rights Act, which this man is very carefully studying. I love my marketing team. And that says that the services must be performed with reasonable skill and care. So in essence, you need to provide the service that you say you're going to, and you need to ensure your care is suitable and safe. And again, you're backed by your CQC requirements anyway, so shouldn't be an issue. The more important bit is your contract terms need to be fair, transparent, and you need to highlight your key terms so that service users and their families can understand all the essential features of what living in your care home involves. The weird bit of legislation that applies is this one, which is the Consumer Contracts Regs 2013. If I was doing this in person, I'd ask for a hands up as to who thinks this should apply to care homes, but you're probably most familiar with this when you're buying something online and you've got a 14-day cancellation period to change your mind. Very oddly, this can apply to care homes where you do not sign a contract face-to-face with a resident or their family. So if you sent a contract out and it was returned to you by post, this would apply and essentially gives residents a 14-day right to cancel. What I would say really about this is it just needs to be in your contracts. A carefully written contract will make sure that if a resident wants to come in within that 14-day period, they can just agree with you that they're going to do so, and then that cancellation period falls away. But I'm just making you aware of that sort of odd bit of law that does apply. But we can come back to that if there's any questions, which there might be. So, the Competition and Markets Authority, this body is the kind of enforcement of consumer law body. And I'm not going to talk you through the kind of history of how we got to where we got to, but some of you may remember that back in sort of 2017, 2018, the CMA launched an investigation into elderly contracts, elderly care contracts. I think they'd had a lot of complaints, so they decided to have a really thorough look at the market. And as you'd expect, they kind of went for some of the big organizations first. So the first major investigation and outcome was in 2018 when Maria Maliband dropped their after death fees, so the fees they were charging residents after death following the Competition and Markets Authority action. And the CMA then published advice on their interpretation of what's appropriate to charge residents in terms of fees after death, and their interpretation of the consumer law I've just talked to you about. And that was followed pretty quickly by a Sunrise Senior Living case, which was quite niche, to be honest, but they ended up having to pay out £2 million in compensation to existing and previous residents' families in relation to fees they had charged up front for maintenance of communal areas. And basically the CMA said that they hadn't been clear enough about what those payments were for, and therefore they were unenforceable, and Sunrise Senior Living had to make those payments. And what happened after that was this enormous piece of guidance was published in 2018, which was the CMA's view on what is fair in elderly care home contracts. And that is that exists today, although it's been updated, and I've put a link in for you if you want to have a look. But this webinar kind of summarizes a lot of that document for you. It's not statutory guidance, and statutory guidance is binding. No one's ever really been sure how binding this document is, but it formed the basis for the CMA to start going after some of the big guys. So they then went after Care UK, Barchester, Hallmark, the Fremantle Trust, with some very mixed outcomes. And understandably, some of those organisations lawyered up and had a fight with the CMA about their interpretation of consumer law. And that all went on for the next sort of 2 or 3 years. Some of the cases CMA won, and then they started to lose them. So they discontinued their claim in 2020 against Barchester, which related to upfront administration fees. They won one against Care UK for unfair top-ups for NHS funding, and then they lost in 2020 in the High Court against the CMA in relation to some administration fees. And then they updated their guidance in 2021, and that really was the last we heard of the CMA on this point. But which brings me to where are we and what is the legal position for you operating care homes and your contracts today? So I think the most important thing to say is that consumer legislation remains in force. So those 3 bits of legislation still apply. What is less clear is how those are applied in terms of contracts. The CMA have got new powers from the 6th of April 2025 to enforce consumer law, and they can fine providers or organisations, any organisations, of up to 10% of their turnover. They can also open direct consumer enforcement investigations and apply to court. So that's the body with the power. As I said, the status of their guidance is unclear, but our advice to our clients is ignore it with caution. And when we're helping clients with their contracts, we are very clear to advise on what the guidance says, but also try and strike a balance between the guidance and commercial needs of care providers, because there is some conflict between the two. But it's not just the CMA. Trading standards can have powers of enforcement, and we certainly saw them in action during the kind of 2020 period. Probably most importantly for you is the other parties to the contract can look at this and challenge your contracts. So as you know, you only need one lawyer in the family to cause an issue, and we quite often have clients ring us up where so and so's uncle is a lawyer and he doesn't like X clause. So that's probably your sort of on the ground issue with contracts. And then the CQC, the Advertising Standards Authority, if your advertising is misleading. The Ombudsman can get involved. There was quite a famous case a few years ago dealing with FNC, which I'll cover in a minute. That's people's ultimate complaint appeal. If complaints aren't dealt with in someone's eyes adequately by you, they can go to the Ombudsman. And then finally, the local authorities and the NHS can be interested, particularly I think when it comes to top ups, which again I'll touch on a little bit. So that's probably the kind of driest bit of this. So let's talk about some of the practical things that are going to be of more interest to you. What are the key stages you need to focus on when you're looking at this consumer law element? Basically, you need to think about it in terms of first contact. So whenever there's an initial inquiry made to you, and including showing people around, you need to think about it in terms of actual admissions and your contract pack. I expect everyone does it differently, but lots of you probably have a contract pack, an admissions pack that you send out or you give to somebody. And then you need to think about it in terms of emergency admissions, which are obviously more difficult to deal with. So the key thing is it's really important that the information you provide is complete and truthful, and you highlight any key terms. I often sort of weirdly draw an analogy between service user contracts in care homes and mortgage agreements, because this agreement for someone to come into your home is an investment and is a really, has a very high fee attached to it, similar to when you sign a mortgage agreement. And probably you've seen in mortgage agreements quite nicely at the start, there's often a key terms document which sets out all the nice key bits of the mortgage that you need to be aware of, and then there's all the small print behind it. And I think that's a really good approach to dealing with admissions into care homes. It's really important that families and residents are given a key terms document so they can see what the key terms of your contract are with them. And that might include things like funding arrangements, key important bits of your home, whether you've got any requirements for them to show financial viability, how fees might change, upfront payments, deposits. Could everyone go on mute? Because it's really, I'm getting some feedback.
I think I got lost on the way to Newton Abbot, which I'm only done.
We'll go through and mute it, right?
Thank you. So yeah, what I was saying is it's really sensible to put all of your important things down in a key terms document. And if your staff are taking phone calls to deal with inquiries, they can use that as a crib sheet. And you could also potentially put that on your website, albeit I suspect your sort of more commercially sensitive information like fee rates you'd prefer not to. And I think there's an important bit here about training your staff during initial inquiries and show rounds so that you can be really clear that they have given the right information and highlighted the right things. Emergency admissions are more difficult. I can't profess to sort of being on the ground to know how that works, and maybe that's a question or a discussion we can have at the end. But I think my advice really is with emergency admissions just to do your best to get key terms and contract terms in front of residents and their families at the earliest stage, so that if there was any question over whether someone had been sort of given the information, at least you'd be able to try and tick that box. But yeah, I mean, it would be good to chat that one through. So the contract itself, I see a lot of contracts. Lots of them come to me because people want me to have a look at them, but lots of them come to me because I buy and sell care businesses. And there's lots of improvements that can be made across contracts. And I tally up a lot with, I suspect lots of you have met Mei Ling, who's one of my colleagues. She tends to deal with the kind of debt recovery side of this. And we do a lot in tandem trying to help care homes get their contracts right, because if you get your contract right, it's a lot easier to try and recover unpaid fees, which is very helpful. So I was just going to go through with you some of the key things that I'd look for when I'm looking at a good contract. And this is seriously stating the obvious, but do get your contract parties right and make sure the full names and addresses of everybody are documented and that they actually sign the contract. We've seen plenty of contracts where there's just a name of maybe the party who's paying who isn't the resident. So it can be really difficult to take enforcement action without full details. And people do disappear occasionally, which is not helpful. Be really clear who's paying, who's got the capacity to sign the contract. Is there a power of attorney or deputy in force? And have you seen copies of the relevant documents? Again, it can be really useful to have maybe on your admissions form, a tick box of what documents do you need to see to show that the contract and who's signing is valid. Does someone need to guarantee the fees? If so, those need to be really carefully explained and worded. Financial viability is a huge one, and again, I'm always interested in hearing how clients approach this, because I think my experience is lots of clients are really nervous about asking prospective residents for proof that they can pay private fees for a period of time. And because I can be objective about this. Again, like I said, look at it like an investment and a mortgage. You are asked all those questions when you're entering into a contract for a lot of money, and there's no reason why, when your great care homes are expensive, and rightly so, that you shouldn't have some proof that someone can pay for the foreseeable future. You know, it in mostly because, as I understand from talking to lots of you, you need to plan for when somebody may run out of funds and the delays that the local authorities inject into the process at that point. I think it's a really good idea to have a financial viability checklist that gets provided to prospective residents, which asks them how they're going to pay and asks for proof of assets, bank statements, property, especially property, because if a property needs to be sold, you need to deal with that. And I think that whole conversation about financial viability can be worked into every aspect of your admissions process and explained really well in advance, so it doesn't come as a shock. I've seen really good approaches with, again, documents that can go on websites or go in admissions packs, which talk about funding and explain local authority funding, how it works, how top-ups work, how someone's needs might impact what they pay. All that sort of thing can be dealt with really neatly in a separate document. And again, it's something, you know, we can help with if needs be. Deposits, something we see quite a bit of. There are generally two types. There's security deposits, which are the ones we see the most, and that's basically trying to protect you from unpaid fees or damage. And these are acceptable, provided that the amount is proportionate. So if you're already asking for a month's fees in advance, you could ask for a security deposit as well, but you probably wouldn't want much more in advance. You need to be really clear in your contract what the purpose is and how it will or won't be returned, and have a process in the contract for resolving any disputes over a deposit. The CMA would love you to ring fence deposits in separate bank accounts. I suspect that's unlikely to happen, but that's how kind of extreme some of their positions are on this stuff. Reservation deposits are a little bit more tricky. I don't see them a great deal, but I have advised on them. They are okay as long as you're really clear that they can't be non-refundable in all circumstances. So if the actions of the care home prevented somebody moving in, or the room wasn't ready, or you for some reason withdrew your offer of a place, then the deposit would have to come back. And they're really there to protect against risk of late cancellation, aren't they? If you've got a waiting list and someone wants the room, so that's their purpose. And when someone does move in, they should be credited against the first lot of fees or returned to the resident. Upfront fees, as I sort of alluded to with Sunrise Senior Living, they're generally not okay. I think what we're talking about is where you ask for fees for assessments and things that should just be dealt with under your fees. There's not really a kind of blanket approach to this. So what I'd say is it's a bit of a red flag. And if you do charge upfront fees, maybe seek some advice on whether those are going to be consumer law compliant. Changes to fees, by which I mean increases during the time someone's at your home. These are really tricky to navigate from a legal advice point of view. When the CMA were sort of after everybody, I thought this was going to be one of the areas that got tested in court, and I was kind of waiting with bated breath to see what happened. And it wasn't, and it hasn't been. So it is really difficult to say what you can and can't do. What I can say is that the premise of consumer law is that your residents need to be able to foresee when they accept a place how changes to fees might be dealt with and how they would be affected. It's really clear that you need to give advance written notice of fee changes, and I know that that is part of the course. I often see clients only give 28 days notice of fee increases, and I would say to be consumer compliant, that probably needs to be 6 weeks at least, because on the basis, and this is the theory, not the practice, if someone didn't agree to those fees and wanted to move from your home, they need longer than the 28 days notice, because that's the only notice that they can give to end the placement. I do recognise in saying that it's very unusual for residents to want to move care homes, but looking at that from a completely sort of legal position, that's the advice we'd give. The CMA guidance on this issue isn't commercial at all and suggests that you should not have an unlimited right to increase the price of your service, as the resident has no choice but to pay it because they don't move very often. I think from what should I do then? Just try and make sure your fee increase clause are as clear as possible and provide the resident with as much information about what might go into a fee increase as you can. The kind of perfect clause would maybe include reference to a toolkit that you might use, or to references in consumer pricing index or national living wage increases. Broad caps, i.e. it won't be more than X% are frowned upon, but it is okay to have a clause that says in exceptional circumstances we can increase the fees. So things like utility costs, when the Ukraine war kicked off and everybody's utilities went through the roof, that was that triggered a lot of fee increases. So things like that, new legislation, you'd be able to have a clause that covers you for that. And also very specific circumstances, like if someone wants to move to a more expensive room or their needs change, those things are fine as long as you have a sort of consultation period on stuff like that. The kind of fees funding clause I see missing the most is what happens on changes to funding. So if somebody moves from private to local authority funding or local authority funding to NHS funding, my advice is your contracts set out really clearly what your parameters are. So if you require top ups to local authority or NHS funding, and I can see the shocks because no one thinks you can top up NHS funding, but you can in certain circumstances, then you need to be really clear what happens if a top up can't be paid. Do you have the right to end the contract? Will you take someone on local authority fees? It's just about being really clear to residents and their families what will happen. And I think from a practical point of view, again, that's why it's really helpful to have a document outside of the contract that explains all this, because otherwise you almost get backed into a corner when someone doesn't realize what the impact of a change in funding really means for them and their care. Limitation of liability clauses, that's a legal kind of thing. I often see these where maybe someone's cobbled together a contract with a bit of legal input, but generally they're not very useful in this sort of contract, because anything that includes indemnities or legal jargon is pretty frowned upon by consumer law. So it's almost safer not to try and include a limitation of liability clause and rely on a good contract and your insurance to deal with any issues. You can't.
We've got a hand raised. Are you happy to take questions?
Oh, sorry. I will take question. Yes.
Trian?
Hi, thanks, Lucy. Hi, Hazel. Just can we come back to the top-up point? What is your advice about what that document should say? So if a top-up funder defaults on payment, should that in effect terminate the underlying placement contract or not?
If you could bear with me, I'll deal with top-ups in about 2 minutes. Is
No
that
problem,
all right,
thanks.
Trian?
Yeah, sure, cheers,
No
thanks.
worries. I'll park the question. From a liability point of view, you cannot exclude or restrict liability where somebody suffers personal injury or death due to your negligence. That's just how the law operates. So any kind of limitation of liability has to be worked around that anyway. Visiting, this is just a note really from experience. The pandemic, from a trying to help clients point of view, this came up a lot. I think that the visiting guidance, the way the government dealt with that was pretty awful, because I think it took me about a year to realize that somewhere in the annals of the government website was all this legislation about visiting, which was completely different to the guidance they were putting out. And when we went to the actual letter of the law, it was quite different to what we thought we were advising on, which is a lesson in itself. But my sort of suggestion with visiting is you have a really robust visiting policy that gives you lots of flexibility in the event of a public health crisis and or very difficult families, which I think is the one we get questions on a lot. And then your contract can just refer to the visiting policy, and it kind of all becomes binding that way. So again, if people want help with visiting policies, we can look at that.
Hazel, I think there's a bit more on that at some point, isn't there? Because if the government guidance wasn't entirely in line with what they actually were legislated to tell us, it does leave it quite a grey area for us when we're sort of at that front-facing point, isn't it, to sort of then gatekeep.
Yeah, it does. And I mean, it was so difficult, wasn't it, during COVID to manage expectations. And I think I found the law more helpful when it came to residents with learning disabilities, where the situation was so difficult because of capacity and the smaller homes that often support those individuals. But I think, yeah, I mean, I guess the COVID legislation is gone anyway, but it was really just a kind of lesson to us all to really look beyond what government guidance tells you and make sure that the law sitting behind it is correct. But there were lots of good things we took from visiting policies and practice that we can help with if needs be. Just be mindful of lack of capacity and best interests, because those are always difficult to navigate. Termination, ultimately, the Protection from Eviction Act 1977, still in force, requires you to give 28 days notice if someone didn't want to leave your home and you needed them to leave. The situations we see that applying to tend to be around where someone's needs can't be met by your home anymore and the local authority aren't doing enough to move them. And therefore you're at risk of being in breach of your CQC registration. You may have to press go on I mean, it's a horrible place to get to, isn't it? But you may have to press go on a protection from eviction notice. The other situation where we've seen that apply is particularly where somebody's family are just so horribly behaved that you and your staff can't manage them anymore. So, I mean, just to be aware that there is a legal process that can be invoked if you're really desperate to do so and you feel that the home's at risk without. Outside of that, I think it's just about being clear when you might give notice. So, you know, that's quite likely to be if you can't legally meet someone's needs anymore. If they fail to pay, I mean, in all the years we've helped with debt recovery, I don't think I've ever seen any appetite from our clients to evict someone from failing to pay. It really is absolutely the last resort, isn't it, when you're caring for somebody? But I think from a contract point of view, it's good to have it in, and it's good to have a bit of a kind of grace period. So if you haven't paid by X, this is when we would do this, and try and build in obviously consultation with families and so on to try and resolve the issues. But it is very difficult. I realize I'm sort of talking legally and the situation is much more difficult to manage. And obviously someone's behavior if in extreme circumstances, in which case, you know, you may have to get local authority involved and all the rest of it. But as I said, you do have there is an ultimate protection from eviction process you can go down. Fees after death. I mentioned the Maria Maliband case. I would say this is law really now. It was upheld that this is the CMA were right in this situation, and the rule for private fees is that you can charge for up to 3 days after death, or until the possessions and the rooms cleared, with a reasonable backstop of 10 days in total. So if somebody clears a room within 3 days, that's as much as you can charge. After the total of 10, you can agree an extension with the family if that's the sensitive and appropriate thing to do. Unless obviously you've found somebody else to occupy the room, in which case you shouldn't be charging to lots of people, but I'm sure that doesn't happen. So that's probably one to look at if you're not aware of that. FNC, as I said, there was an ombudsman case a few years ago. Lots of people deal with FNC differently. The only rule is just be really clear in your contract how you account for and deal with FNC. So if you collect it and keep it, that's fine. And it has nothing to do with what you charge your residents, that's fine. You just need to say that in your contract. That's quite often how we see it dealt with. Top ups, and yeah, happy to sort of unpick any questions on this. Top ups ultimately should be paid by the local authority under the Care Act. So they should be agreed with the local authority, and the payer of the top up should have a separate agreement for the top up, because ultimately if somebody fails to pay you the top up, the local authority should pay it, as long as the local authority is aware of it and have an agreement with the third party. In practice, what can happen very often is that the top up comes straight to you from the third party, but sitting behind that is that legal process. So under the Care Act, top ups must be entered into with the knowledge of the local authority, and that is your protection. It's better to do it that way. It's safer for you. NHS funding, you can charge top-ups. They don't want you to think you can, but you can in very limited circumstances. So you can't ask for a top-up for the cost of the care package, and i.e. for the assessed healthcare needs that the NHS pays for. You can't top up for a shortfall in the funding, but you can for what is called additional private care services, which the NHS wouldn't fund. So if you can be creative around sort of luxury packages, bigger rooms, that kind of thing, it is possible. You do need to be careful, and that you sort of have to separate the two out a little bit to be able to do it. Because ultimately, if someone doesn't want to pay for the extra things, they need to still be able to be at your home with the NHS funding. So it's just something, we can talk about that if anyone's got specific issues. Shrin, did that answer your question on top-ups?
I had to log off, so I'm not sure. So let me ask it again if that's okay. If you have a top-up in place, so the position that we've got in Devon is that the new old Persons Fee Model terms and conditions seek to have an extra services element in there. So we've asked them to go back and define what is a top-up and what is an extra service. So if you are buying 4 hours of additional care every week to escort you out because you want to go shopping, is that a top-up or is it an extra service? If escort hours are an extra service, and they've not come back to tell us their formal opinion about that point, especially if socialisation is an identified Care Act eligible need in that person's assessment. The top-up that you charge, does that, if the termination of the top-up or non-payment of that top-up, should that terminate the underlying care package if defaulted upon? Or is there a link, that causal link, that needs to be made or not made between those two charges?
That's a lot of question, and probably one I'd need
Really?
to look at the context.
You expected a simple question from me after all these years?
No.
Really?
Yeah, I mean, ultimately the top-up meets the shortfall between local authority fees and the cost of the placement, and there's obviously quite a lot of devil in the detail in what the scenario you've asked about, what the local authority is funding. So that is definitely one I'd park and look at with you separately with the wording and so on, because the local authority have to pay to meet the needs of the person, don't they? So
sure. So happy to park it. Just if I send you the latest T's and C's.
Yeah, do.
I've sent back in the form part. They can't answer the question either, and I feel that's an opportunity for providers here. Yeah. Under that, so if I send you that, and I'm sure Robin would love to engage RWK for some generic advice around that.
Yeah, thank you.
Yeah, cool.
So that sort of deals with contracts in a a fairly brief thing. As I said, I think the experience we have at RWK is trying to look at the whole thing from the top down, because we get lots of issues with debt recovery, and the soundest advice we can give to you all is to make the contract really important in your process, highlighting key terms, highlighting the need for someone to be able to show you they can pay for their place at your home, highlighting what happens if they can't, and how early they need to get into discussions with local authority, and really surrounding your contract with good documents and good conversations. So this flows through your whole process from first contact with somebody to signing contracts and coming into your home. I think training staff forms a really important part of that, and registered managers have such a massive job, and it's just trying to have the team that can really work this process so that the home's protected and your residents and their families are protected and well informed, and then hopefully it takes out the risk of sort of more difficult things arising along the way. I mean, you're never going to eliminate sort of issues with debt or challenges where you can't meet someone's needs anymore, but it's sort of about preparing people, isn't it, for their admission into your homes. I think that was it from me. I hope that is helpful to you. I am working with the board to try and work out a package. We've got we've worked over the years at providing putting together a template residence contract, which it is hopefully sort of walks a good line between the CMA's position and commercially protecting your commercial interests, which comes with some detailed notes. We can also offer, tailored residence contracts for people as well. But as I said, I'm working with the board at the moment to see if we can agree a package for your members. So hopefully there'll be some more information on that. But I'm very, very happy to try and answer questions best I can on most things in this talk. If people would like to,
that's really helpful. Tour Homes asked about top-ups again. Can they be charged on D2A funding or just CHC NHS funding?
I don't know the answer to that. I've looked at it from CHC NHS funding's point of view, but that's certainly one I can take away. I can do it.
Might be worth. It seems to be a bone of contention at the moment with Devon, because obviously under the Care Act there are various different thoughts on it.
Yeah.
I can't find the answer myself either. Philip, did you have a question or a point to make on that? You're on mute, I think. Sorry.
All right, there we go. That's better. I think you can hear me.
Yeah.
Just wondering, not sure, I didn't join right at the beginning, so apologies if you covered this, but did you mention, for instance, liability for damage to items in the care home, particularly perhaps people who don't have capacity and damage items?
Yes, well, not specifically that, but yes, I did in the context of charging security deposits and asking for so having an amount of money that you can withhold if there is damage. I mean, I think what do I think about? I think if you've got residents who are more inclined to damage, and that's the sort of residents you have at your home, I suppose that needs to be kind of taken into account in your overall fees that you charge. But if you're trying to protect against just the situation where occasionally someone does really damage a room, then I think security deposits are the way forward. But you just need to be really clear.
Is there no way of putting that in the contract that if should you cause any damage intentionally or unintentionally to, for instance, call bells or carpets or you will be liable for that?
Yes, yeah, there absolutely is. Yes, there absolutely is. I think what I was saying was I think you just need to consider it in the context of the overall category of residents you look after. But yes, there is, and you just need to have a very clear clause that says that, and a process for arguing it out if somebody challenges that. So yes, you can.
Okay, thank you.
Anybody else? I haven't got the chat up in front of me actually, because I'm still sharing my screen. Is there any other questions, Lucy?
No, not that I can see.
Okay.
I think we're sharing the slides anyway, aren't we? So I'm sure there'll be. Oh, Dom. Hi, Dom. Any queries?
Hello.
Hello.
Hi. Hi, Hazel. I was just going to ask, hello, right at the beginning when you were saying that you kind of need to have like chats with people about financial viability, and people are nervous to ask, and what proof and what questions and that sort of thing. Are there any kind of practical, I mean, I think ours are almost the other way. They're like, I don't have any money, don't you worry, you know, that kind of thing. Like, you know, got about £4.50 and I'll show you it, and that's it. But so we don't tend to have that where they kind of want to dive into being private or anything. But what kind of tends to work well? You were saying about kind of ingraining these questions into people, just in terms of, I think we go down the route of, we try and explain a little bit about the local authority, but then we're very keen to say, speak to the local authority, because you never quite know when they're going to change. Do you know what I mean? Yeah. So obviously it's not us, it's the local authority, but opening that up, like, what do you ask? Like, what do you ask for? Do you ask for bank statements? Do you know, what's not embarrassing? Like, we're so British, aren't we? Like, you'd never say.
That's it, isn't it?
I don't know. We kind of just tend to take, it's awful, isn't it? Shouldn't say, but take them at their word, really.
Yeah, I mean, I did a checklist for somebody, and it was really around sort of sources of wealth. So do you have a property? Is the property on the market? If not, are you proposing to? Do you have any savings or investments? Can you tell us what those are and send us proof? I mean, it was, I think I got it onto a page of A4. It was not a particularly detailed document. It was just some common sense. There's no legal magic to this. I was sort of, someone asked me and I was like, yeah, I'll put my head to that, but it's just was kind of practical stuff. I mean, I think on your other point around funding, again, it's just a one pager explaining in very basic terms funding, and that there is a threshold, and there are things like deferred payment agreements and 12-week disregards, and actually what does that mean for you as a resident, i.e. we might still want a top up, and by the way, if you run out of money, it probably takes 6 months for the local authority to get their act together, so please tell us really quickly, otherwise your place may be at risk, which, as I said, probably isn't going to happen. But I think people need to sort of see that is, you're not just going to sort of fund people on private fees if they can't pay them. Well, we probably are, but
we do. That's what happens. I know that. Hang on a minute, what's gone on? Wow. I mean, that's the reality of it, isn't it? But to let people know, of course. Okay, great. Yeah, that's really good. Thank you.
It's just trying to point people to doing things, isn't it? Rather than we're going to pull the rug from under your feet and you're going to have to move your mother or father. It's just trying to focus people's minds on what the reality is, isn't it? But
what are the main things that people come back on with regards to the contracts and things, the key kind of, because we, touch wood, haven't really had too much coming
do
back
you
on
mean
us. Like, for
what
residents,
do they challenge when they read it, or what are the issues?
Well, on, I suppose, what are they challenging and you're having to deal with, type thing?
I think we don't often get the case where somebody, well, this is only stuff that comes to me. We don't often get people ring us and say, oh, so and so's relative has read the contract and they've queried clause X, what do I do? Occasionally we've had something like that. I'd say the stuff where the contract comes into play is around fees and debt, and that's when
that's the biggest thing.
We find some real flaws. So like I said, it's really difficult to chase up someone who's only signed a contract and there's no record of sort of who they are and how they're connected to the families, and that does happen, believe it or not. And really basic things like, can I charge interest? Can I recover my fees of engaging you know, us or whoever to chase the debt, at what point can I ask a resident to leave? And you know, we've had some really tricky ones with residents' needs just being too much for homes, and then the local authority saying, oh, we'll let you know when we found them somewhere, and you know, clearly the client's in breach of their registration by continuing to care for that person, and it's very often connected to behavior that staff can't manage. So it just becomes this kind of really stressful wider thing that impacts lots of your staff and so on. So I'd say, so you know, some of those are the kind of contracts contracts are one of those things, aren't they? Mostly you just want to put them in a drawer and no one look at them again, but actually when the, you know, the proverbial hits, that's the thing that comes out and you can work out where you go next. So that's the reason to have a good contract.
We had a classic one a while back where we had a resident who was selling their house and it was taking longer than they thought, and she had the audacity to tell her son that it was fine. We'd fund her bridging loan for her until it got sold. We're like, no.
I mean, the house one actually is worth discussing because this comes up a lot for us. I think if somebody has got a house to sell and they owe you lots of fees, there are things you can do, and you obviously need the cooperation of families and residents to do this, but you can get engaged with the process. You can get undertakings from solicitors who are doing the conveyancing to make sure that as soon as the house is sold, the proceeds come to you. There are things you can do that protect you a little bit rather than just hoping and waiting. So, you know, it can be useful to have things like that in your process as well. And that's a reason for
disregard could be useful in some respects, can't it? But it is only 12 weeks, so it's a bit of a...
Yeah, it is. But it's just knowing what levers to pull, isn't it, in those situations? There is absolutely no magic wand, but there are things you can do to help your cash flow and have a bit of protection. So we do spend quite a lot of time helping with that sort of stuff.
Tom, I was just going to say that a resident's family member told me that Devon were charging them quite a high rate of interest on there because they are, I don't know what they haven't managed to sell a property, and instead Devon are funding, and they're charging them quite significant interest. But obviously, you know, I had also done the same for them prior to them being able to release some money, and there was no interest whatsoever. So I just found that quite interesting. I was kind of, they sort of merrily told me that it was great because I hadn't charged any interest, but Devon were. And I sort of just went, okay, right. Yeah. That is interesting. Thank you so much for telling me.
It's a small point on that note because I don't know about you, but I don't find kind of charging of interest that it's always sort of buried in a clause somewhere in a quite a legal fashion. And actually, an approach we've helped clients with and changed in contracts is charging a fee per day for late payments. So there's nothing to stop you saying in your contracts, for every day a payment's late, we'll charge you £25 a day, which if anyone reads that clause, which is an if, I think that can be a better deterrent for payments being on time than an interest clause, actually, because that's someone in your organization's time spent sending a chasing email, isn't it? And it's all cost for you. So it's something you could draw out in a key terms and enforce if you wanted to. I mean, this is just if people don't pay on time, isn't it? Rather than more complicated funding situations. But it's a minor point, but one to note.
Lovely. All right. Thank you. Not see any more queries or anything. Thank you for your time, everybody. Has anybody got any other queries or anything they want to raise at all? No, fine. Hazel, that's really helpful. Thank you very much. Made me think of quite a bit.
Thanks for having me.
Working away in the background, thinking about various bits and pieces. We'll share the recording on the website and also slides and bits and pieces. And then obviously we'll bring you news, everyone, about this possible kind of contract package that we're talking with Hazel about. But yeah, thank you very much for your time, everyone. Marvellous.
Thank you so much. See you all.
Well done, Hazel. Thank you. Nice to see you again.
Thank you. Bye-bye.